Hi, hello. How are you doing? Hello. Hope you're fine. Hope you're good. Welcome to Lawrence Info Hub. It's always a pleasure to create content on this platform. Today we're looking at when an accused jumps bail. What happens? Yes. Are you a law student? Are you a lawyer? Whether you're a young lawyer, you're an old lawyer, knowledge is like light that eradicates darkness. So today we're here to discuss this important aspect in criminal trial, in criminal laws, in our criminal law series. Now, when a person has been arrested, the person is like an accused person, and the person is taken to court. The first thing that usually happens is what we call um, bail. Yes, the bail of the person is what his or her lawyers will be fighting to get. Now, where it happens and the bail is granted, there are conditions of the bail. And when the person meets those conditions, he or she is granted bail. When you are granted bail, it's more like a conditional thing in the sense that you're no more in detention, but you'll be coming to court throughout your trial. Now, when a bail is granted, there's usually a surety. The court will make provision for a surety, a bail bond, and all of that. When you satisfy all of those conditions, you'll be released on bail. Now, many a times, many people feel that at the point you have satisfied your bail, that is where the case ends. That is where the case starts. That is where the case starts. But there is this idea people have that once you have satisfied your bail, you can choose to come to court, you can choose not to come to court. As much as we have delays in the dispensation of justice or in the criminal justice system, that doesn't mean that we should take it as a laissez-faire attitude. So, as a lawyer, you should be able to advise your clients properly. That in as much as you are on bail, it does not mean that you have been exculpated from the liabilities of the criminal liabilities involved in the crime for which you have been accused of. It means that you should be coming to court. You're just given bail temporarily for you to be coming to court till the end of that matter. Now, when most times when people are granted bail, they just japa, they just leave, they just travel, they relocate, they don't know the implications of what they are doing. So today we're looking at it briefly on what happens when an accused jumps bail. Now, you must know that as much as bail is a constitutional right of an accused person, it's also granted by the discretion of the court. We have seen instances where courts, failed to grant bail and, been back and forth, going to court, arguing, and all of that. We've also seen where courts grant bail, but on very stringent conditions. We have also seen where court grants bail on just very calm, good conditions which are easily met. But be that as it may, once it is the knowledge of the court that an accused person has jumped bail, and before it can be ascertained that the accused person has jumped bail, maybe it didn't come to court the first time, the second time. Most courts will not even wait for you to get to the third time. On the second time, the court will just revoke his or her bail. Once the court revokes his or her bail, the court will issue a bench warrant. That's one of the first things the court does. Some other courts, they will allow it two times. Maybe the person didn't come to court and brings maybe medical report, I'm sick, or call the prosecutor to say, I traveled, I'm not available, I'll be available at the next adjourned date. We've seen instances, even where the prosecutor is saying, the defendant called me to say he's traveled or he had a burial, he lost someone, there was an emergency, that's why he's not coming to court. Or even the lawyer to the accused person will say that. Now, on the second time, and the person meets court, the court like, what is happening? Maybe if there's no excuse, you see the court to write down on this note that if on the next adjourned date the defendant does not show up, he's going to issue bench warrant. And so that is what happens when a person jumps bail. The first thing the court does is that it revokes his bail or her bail and issues a bench warrant. That bench warrant is for the police to arrest such a person and bring the person back to court. To bring the person back to court. So the first thing the court does, revoke the bail. Second thing it does, issue a bench warrant. Then the third one is that the accused person forfeits his bail. That is the bail bond, forfeits it. Forfeits his bail. And the fourth one, the surety who stood for that person is ordered to pay the stated bonds amount into the court registry. Now, when the accused person forfeits his bail, when he is arrested again, he will have to go through the hall of getting a bail again, if the court will even grant him. So when an accused jumps bail, it's a very dicey situation. He has put him or herself into a precarious situation that, first of all, even have thought, yeah, what is telling the court is that I'm not a responsible citizen. The fact that I'm not even trustworthy, and the third fact that I'm even guilty, because the court will feel like, why are you running away if actually you're not guilty? Why are you running away? So it projects to the court the kind of person that person is, and it weighs on the mind of the court for further, you know, applications that will be made to the court in favor of that person. The court will look at, you jumped bail, so I don't think I can even exercise my discretion to your favor. So it has negative impact on the case. It has negative on the personality of the person, and for the lawyer who is representing their defendant, it makes the work more difficult, because the court looks at their client as, this one, I can't give him breathing space. So the first thing the court does is that your bail is revoked. So when you jump bail, the accused bail is revoked. A bench warrant is issued for the police to rearrest the person. The person becomes a wanted person. The person forfeits his bail, and the bail sum, the surety who stood for him, is made to what? Pay the amount, the bail bond into the court registry. Now, before the court forfeits the terms of the bail, the surety must be given a fair hearing. The person will be invited, sometimes arrested, yes, brought to court, and the court, lets him know the situation on ground, and that the fact that this person is no more available, that the liability falls on him, and the fact that whatever the bail sum is or the bail bond is, you're not supposed to pay to the court registry. Now, the surety is given that of privilege to explain his involvement in the accused person's disappearance. You have to also show cause why the bail, the conditions of bail to which he is a surety should not be forfeited. This is very precarious. Now, this is where I now tell people, before you stand as a surety to somebody, you must know who that person is. You must even know the whereabouts of this person. The person even have to be accountable to you. You can't stand bail or stand as a surety to somebody you don't even know his whereabouts, you don't know where he lives, you don't know what he does, you don't even know him, for some pecuniarity, for some consideration. No matter how much it is, you should, when people stand as surety, sometimes they don't even know the legal implication of what they are doing. So once a person jumps bail, these things have listed that is what happens. And for the surety, for the court to make the surety to be liable in terms of paying the bail's bond to the court registry, the court will be allow him to express himself, hear him out, and know the level of involvement with the accused person. I know when this bench warrant is issued and the accused is rearrested, the possibility of getting another bail will be very, very difficult, because you've already told the court that I'm not trustworthy. Just like I earlier stated, you can't even trust me, and I'm going to jump bail again. So it's very important, whenever you're representing a witness, an accused person, a defendant in a criminal matter, to let him or her know that this is what it means. You're on bail does not mean you have been freed. Now, another thing is too, that for a surety, when he's been given that opportunity to express himself, to explain his linkage with the accused in terms of his disappearance, sometimes you see the surety apply to the court to be discharged. You apply to the court to be discharged, like I can for so reason, I want to be discharged from this suretyship. That's another procedure altogether. Now, the accused, when he's arrested, will not be released until another surety is what provided. So it's kind of the criminal law proceedings is not something, the way it's not a laissez-faire thing. It's very strict. So once you are involved, or you are charged, or you are accused for some reason, you must be up and you must know what you're in. It's not a tea party, till the matter is sorted out, until you're discharged or you're convicted, whichever way the matter goes, you know, it's very important that you, follow through. I know the court will not just accept any house shorty to even replace the one who asks that he be discharged. Court must know the character, is he acceptable, the good, to the court, the address, and all of that. So, friends, when an accused joins bail, a lot of things goes wrong, and it is very important that we understand whether you are for the prosecution, whether you're for the defendant. For the defendant's counsel, it puts you in a very precarious situation because the court already looks at your client as an unworthy or trustworthy person who who does not respect the rules of court or does not even respect the court itself. So we've looked at that's revocation of the bail, forfeiture of the bail bond, for even forfeiture of your bail, because it's more like once the bench warrant is issued, you've lost it, you've lost your bail. So even if you need bail again, you have to apply again to get it, and it will be very difficult for the court to even grant you bail. So, friends, these are things that happen when an accused jumps bail. So, wherever you find yourself, be it for the accused or against the accused, you need to understand these things so that you know how to present your argument and what you can do at every point in time. And for the defendant counsel, the ball is in your court. A lot depends. Sometimes you see the defendant counsel pleading to the court for one more adjournment to look for the defendant counsel, to look for the accused person to bring him or her to court. So you need to know where you are and how to play your role in a criminal trial. I just hope you'll be able to learn something. If you have any question, please drop it in the comment section. We'll attend to your question by giving you answers that we know that will satisfy your curiosity. If you're yet to subscribe to the channel, please do hit the subscribe button. Share the video. Let other people learn from this video. We believe that it is knowledgeful, and it can help you become a better lawyer, a better law student, in having more understanding, deeper understanding on the practical aspect of law practice. Do take care of yourself.